All right. Good evening. We are at just about 5 o'clock, and we will be starting our webinar very shortly. I just want to say hello. I hope this is working. It's been a little bit of a challenge for me with the technology. So last week was a problem because I couldn't master the technology. We took some time this week to make sure I could figure it out. And here we are live, hopefully coming to you in your house or on your phone or wherever you are. And I'm going to continue with the monthly webinars for a month or two. We generally take the summer off, start again in the fall. The hope being that we can impart some information to you that might be relevant. Also, we are recording these. You will be able to go back on Facebook later and rewatch these or watch them for the first time if you don't have time to finish today. So hopefully you'll get some information out of this and some helpful information out of this. We are going to be covering 3 basic topics today, and my goal is if I get through those with good timing, I will dive into a 4th topic that's always relevant and important. But the 3 main topics of today's discussion are young parents, blended families, and then unmarried couples. So while they sound like they're 3 different topics, they are very related because it is each one of them has an element of how you leave your estate to a beneficiary, an important way you leave your estate to your beneficiary, whether it be a young person, whether it be your own children, even adults, and whether it be a significant other with whom you are not married, or to whom you are not married. So relevant, it should come together at the end, understand how they work, and why it's important to talk about these things. I will stress some of the common mistakes that people make in doing or not doing plans of this nature and things you should be looking for. There are high points in each one of these. So with respect to this, and I'll get started on how I always start. If anyone's watched one of these, they know I always start with the basics. You have to know the basics in order to understand pretty much anything else that I'm going to talk about. So the basics are as follows. We start with the last will and testament, also known as the will. The will is the document that tells the world who's going to receive your stuff when you die and how they're going to receive it. And the how becomes a big part later in our discussion. But the will, so it's a distribution of your stuff at your death, right? Now, what does it mean when you have a will? It means that you also have probate, because it is the probate process that is utilized to distribute your assets to your loved ones or to the people you care about. Probate means that you have a petition that's filed with the court along with a fee, money, and that you have waivers. Now, waivers are forms that are signed by the people called distributees. The distributees are people who would inherit if you died without a will. And all of those people must sign off, acknowledging that they've seen the copy of the will, that they agree that that's your last will and testament, and they agree that that person named in the last will and testament should be the executor, agreeing to all the terms, and they sign off on it. Whether they receive anything or not under the will, they must sign off. This is a common misconception to most people when they hear, oh my God, you mean my brother, my sister, my aunt, my uncle, my kids, whomever is your closest living relatives have to sign off? Yes, they do. It's important to understand that because sometimes using a will and probate is not the best course for you due to family issues. That's a webinar for another day. Suffice it to say, a will requires probate, petition, waivers, death certificate, and the last will and testament. If there is no will, of course, we have this thing called intestacy. Intestacy is New York State's will for you. New York State has a will created for you. It has a predetermined plan as to how your assets will be distributed in case you don't have a will. I suggest that you take some time to create your own will so as not to follow New York State's plan because that may not comport with your wishes. Okay, so that's the will. Will is the first step in the basics. Second step is the health care proxy. The health care proxy is where you appoint someone to make health care decisions for you. Obviously, I'm just clearing my screen here so I can see what I'm doing. Okay. So the health care proxy is where you appoint someone to make health care decisions for you when you cannot make decisions. Obviously, this is important because if you can't make your own decisions, you need someone to do it for you. Now, again, in our world, New York State does have a hierarchy of people that can make decisions for you. However, there are no instructions. The statute does not provide instructions. It just provides a list of people that can make those decisions for you. You may not want the people that New York State picks to make those decisions to be the ones to make those for you. So you need to choose your own. In addition, a well-drafted and well-constructed healthcare proxy will have a couple things in it. Number one, some instructions to your agent to determine or to tell them how you wish to be treated at end of life. Number two, it might have instructions as to how you wish to be treated after your death. It may have instructions to tell the world who's going to dispose of or handle your remains. That's important. You don't want people fighting over your remains. Unfortunately, that does happen. So it may have instructions in there, it may have rules in there, it may have help in there as to how you wish to be treated at various stages. Therefore, it's more important than simply just appointing someone to make decisions. There are instructions and help in there. Okay, so that's important, healthcare proxy. The last one of the three, and one that is underappreciated and is very, very important, is the power of attorney. Now, the power of attorney is so important because New York State, unlike the will and unlike the healthcare proxy, New York State does not have an automatic way that someone can act on your behalf if you become incapacitated. So New York State has a will for you. New York State has people that can act as your healthcare proxy. There is no one automatically to be your power of attorney. Therefore, if you become incapacitated and have no power of attorney, nobody can act on your behalf until and unless they become appointed as your guardian. The guardianship process is long, burdensome, expensive. It involves 2 to 3 attorneys, and that's why it's so costly. It's litigation. It means going to court, seeing a judge. That's not fun. So creating your power of attorney, allowing yourself to choose who you want to be in charge of your assets if you become incapacitated is important. Now, part 2 of the power of attorney is the contents of the power of attorney. The contents matter. And what I mean by that is everyone thinks of a normal power of attorney as appointing someone to pay your bills, right? You become incapacitated, you need someone to write checks for you, pay your bills, keep your house going, make your car payments, any of that stuff. While that's all true, that is but a small part of what a power of attorney does, particularly for my senior clients. What we're looking for is the ability to change or act upon your estate. Because if you go into a nursing home, if that is an unfortunate part of your progression into disability, then we want to have the authority under the power of attorney to move assets, to protect assets, to get you on Medicaid, to do things so that there'll be something left for your family. If that is part of your wish, if that's part of your plan, and you want that to happen, we have to have a power of attorney that has gifting power. This is not automatic when you sign a power of attorney. Far from it. In fact, under the new power of attorney that was created last year, the attorney that creates the power of attorney actually has to take action to put that into the document. This is extremely important. If it's not in there, then you cannot move assets out of your name. Companies, banks, investment people, life insurance companies will not allow you to move assets out of the principal's name. If you can't do that, if you can't move assets out of mom or dad's name, you cannot protect them. This is really, really important. Also, it should have the ability in the gifting power section to create a trust, to fund a trust, to take action on a trust. So again, very, very important. Without that, you are left almost helpless if someone's going into a nursing home. So please, please, please take one thing from this webinar today, and that is get a power of attorney and get a good one done. Okay? All right. So now we're going to slide into our first topic for today, which is planning for young parents. I'm hoping that we have some young parents watching and trying to learn a little bit about how to do estate planning. It does not have to be complicated, first and foremost, but there are some simple rules to follow and some simple no-nos to follow. So first thing, obviously, I want young parents to have a will, and that is incredibly important for young parents. And I say young parents, what I really mean is parents of young people. Oftentimes they are themselves young parents, but I certainly have older parents who have young children. So what we're talking about is creating a plan that provides protection for the young people until they get to some age of maturity. And we'll talk about when that is. So let's say this is a will for husband and a will for wife. In the middle of the wills, we have what I call joint accounts, right? So we might have a house, we might have bank accounts, we might have investment accounts, things of that nature. We also have in here life insurance probably and IRAs or 401ks that are designated to each other. All right? So a good plan, particularly for young people, will include lots of term life insurance. Just as an aside, and I think this is incredibly important, because when I talk to young people about their estate plans, the first thing I ask them about is their life insurance. So as a model metric for determining life insurance on a young parent, I would use 10 times your salary. Okay? Simple metric. That number can be adjusted up or down depending on any number of things. It depends on what your spouse earns. Does your spouse work at all? What do you earn? How much do you have saved? Do you have an inheritance coming? Any number of things can adjust that. But to use our basic metric, 10 times your salary. So if you are a young parent watching this, or a parent of a young child watching this, I want you to think about this in your head. How much do you earn a year? And what's 10 times that? How far underinsured are you? Because if it's significant, you really need to adjust the life insurance. Keeping in mind that term life insurance is relatively expensive. I mean, for a 35-year-old, $1 million shouldn't even cost $2,000 a year. It should be more like $1,500 a year. And so that, when you put that in perspective, the cost is very little compared to the benefit to the family. So I always say to people, it's not the cost of buying insurance, it's the cost of not buying insurance that has to be examined. Because if you die and you leave your family without your income, what's the cost to the family of not having your income? Okay? So I want you to think about that. Now, how do we incorporate life insurance and IRAs into a plan for young parents? Obviously, primarily at this point, we would name the spouse as the primary beneficiary. Who are some of the people we don't name as the contingent beneficiary? This is my biggest problem. Contingent beneficiary. I'm going to put no-nos. So the biggest mistake people make when they come to me and I say, all right, your primary is your spouse, who's your contingent? And they're going to say, well, my contingent is my brother. No, that's not the right thing. Well, how about my sister? No. How about mom or dad? No. How about the next door neighbor? How about the mailman? No, none of those people. And why is that? Because we want, I think, almost always, want the money to end up with the children. If we leave it to any of these people, there is a chance that the money will not end up with the children. Well, somebody would say, well, my brother has already promised me he's going to take care of my kids. Well, that's great, except what happens if your brother's dead? What happens if your brother is in the middle of a divorce and inherits your money? What happens if he just filed bankruptcy? What happens if he just got sued? What happens if he became a drug addict? I don't know. What happens if he's disabled? What happens if he just spends it? I don't know. What happens if he's got lots of debt? All these things could happen, and I realize that when someone leaves it to their sibling, they're trusting their sibling to do the right thing. I'm not asking you not to trust your sibling. I'm asking you to trust life. And so what we do is we do this. Instead, a normal will might leave everything to the spouse, but we'll create trusts for the children. So let's say this couple has 2 children. Now these trusts for these young children are created out of the will, which means we have to get money into these trusts some way by not leaving it to brother, sister, mom or dad, next door neighbor, mailman, etc. So how do we do that? There's 2 ways to do that. The easy way is to put no contingent on there, and the life insurance will flow into the will and then down to the trust. Okay? The trusts then are funded through the estate with the funds from the life insurance, and we've now established a trustee because the will create a trustee. Now here's where your brother steps in. He doesn't have the money in his pocket. Instead, he is now the trustee, entrusted to manage the money for your children. The court would appoint him and keep an eye on him. If he dies, gets divorced, files bankruptcy, gets sued, becomes disabled, the money in the trust are not affected, so your children are not affected. All that means is we have a new trustee appointed. The trust would continue and take care of your children. It is important to understand the distinction between being a beneficiary directly and a trustee. A trustee doesn't own the money, and therefore it can't be taken from them by third parties. So I want you to consider using the will to create the trust for your children. If leaving it to the estate is not a good decision, because let's say you've got lots of creditors yourself. You've got college loans you've got to pay. You've got other loans outstanding. What we would do is we can actually leave, let me use a colored marker, the life insurance directly to these trusts, thereby bypassing the estate and bypassing the creditors. This is a really important and significant use of beneficiary designations and your life insurance to get the money to your children and to bypass any creditors. So if you owe lots of money to, let's say you were dumb enough to go to law school and borrowed a couple $100,000, and then you passed at a young age and still had a couple $100,000 in debts hanging out there, that debt would attach to your estate. The life insurance, if it went into your estate, would be subject to those creditors and to pay that debt. The best way to do it is to bypass the estate and leave it straight to the children's trust, not to the children, but to their trust. Okay? Good way to avoid creditors and thus preserving the money for your children. All right. So, same thing with IRAs. We can leave the IRAs to the children's trust if the spouse predeceases or if the 2 of you die at the same time. That can happen, obviously, car crashes, etc. So we want to be sure that this estate is set up so the children's trusts are protected. In addition to appointing a trustee and then an alternate trustee, you will also appoint a guardian. The guardian, chosen to manage and assist the children and raising the children, should be separate and apart from the trustee. We want to do that because we want the guardian and the trustee to each have separate powers, and we want them to work together, but also keep an eye on each other to make sure they're both doing the right thing for the children. Hope that makes sense. Really important that young parents get this set up properly. It's not hard to do. It's not hard to do it properly. It just takes getting the pieces in place and making a couple changes to your plan. Worth a few minutes of your time. And when we do plans like this for young parents, we do a lot of the meetings via Zoom after hours so that you don't have to miss work, so you're not losing any time, losing anything away from your family. We try to make it quick and easy and painless to get these pieces in place. It really isn't that difficult, but it is important nonetheless. All right, so this is number 1, young parents, very important. So keys, trustees, guardians, alternates for both, and beneficiary designations on life insurance and IRAs. All right? Okay, and I forgot one little thing here. Very, very important. When we create trusts for the children, we need to understand what happens with young people, particularly when young people lose both of their parents. We have to be mindful of that when we create these trusts. We want to be sure that they're old enough to handle the money when the time comes. So we almost never go below age 25. In these conditions, in these situations, it's more like 30 or 35 before we let the children be in charge of this money. Because you have to understand, we're starting with young beneficiaries, and conceptually, under this plan, they've lost their parents at a young age, which means they're far more likely to go off track, unfortunately. So, really important that we set a pretty high age before they can manage the funds so they can really spend some time getting their life in order. We most assuredly want it to be over 25 because it takes that long for their brains to develop. And if you're a boy, or if you have boys, you know it takes far longer than that. I speak from experience. Okay? All right. So, young parents, very important. Not hard to do, but very important. All right. So let's erase this. Now we're going to talk about our next one. Now our next one is a really big challenge. And we're seeing a lot of these situations come into the office. It's called the blended family. Okay? And the blended family, the biggest concern is when you have a husband and wife and they each have children from previous relationships. Sometimes you'll have his, hers, and then ours together. That's also a big challenge. Trying to figure out how to leave the assets to the children, to make it fair, to make it equitable, to make sure everyone's taken care of, and to make sure your goals are accomplished. If you come in here and tell me I want everyone to be treated equally, my children, my stepchildren, everybody, that's great. Let me show you the problem with that. Okay? So, big common mistake. Huge estate planning error. And I'm sure everyone's got a story about their grandparents, their parents, their uncle, their aunt, somebody who went through this. Right? So, we got a husband and wife. Husband, wife. Husband and wife create these wills. And they're going to create the basic, what we call sweetheart wills. Husband is going to leave everything to wife. By the way, you'll see a pattern. I always kill the husband first. It is not meant to mean anything other than I stick to this, maybe because statistically it's more likely to happen. So, husband dies, he leaves everything to wife. Now, the will said that if he were to die, and they each have 2 children, he was going to leave a quarter to each of the children, his children and his stepchildren, because that's what they agreed to do. That's a wonderful thing. Very nice. They agreed to share their money. So he dies, wife's got everything. She comes and says, you know what? A couple years after he dies, she becomes disassociated with the stepchildren. She doesn't talk to them. Maybe they don't get along. Maybe they never got along. What does she say? She says, I'm going to change my will. I'm going to leave everything to my 2 children. And I'm going to disinherit or not leave anything. She's not disinheriting because she's not required to leave anything to his children. So what happens? This is what I call the last to die wins scenario. So whenever I have a blended family come into me, whatever nature the blend is, I say, okay, tell me what you want to do. And as soon as they say, we want to leave everything to the 4 kids equal, I say, well, that's a last to die win scenario. And I say, what do you mean? I explain this. Say, oh, no one's ever going to do that. Well, I can tell you from experience that I've changed estates to leave only to the survivalist children many, many times. That's because they have the right to do that. They can make that decision. This is not a contractual relationship most of the time. There is a way to do contractual relationships and wills. I don't recommend it. So, how do we avoid this pitfall, this common mistake with a blended family? It's really important to think about and plan out a blended family plan. I'm not saying it's easy. It's rarely easy. But there are some things to consider, and particularly in the modern age, where we have clients who are coming in with what we might refer to as jumbo IRAs, $1 million, $1.5 million in IRA or 401ks. We have some opportunity here to make everyone's goals, to accomplish everyone's goals by utilizing IRAs or life insurance. So let me talk about how we do that. So let's say we have a plan to leave everything equally to the kids. But we understand that the last one to die win concept is a problem. What we can do is this. And there's a couple ways to accomplish this. I'm going to start with the easy one, and I'm going to get into more complicated stuff. Easy one is this. Let's say we've got a large IRA. And I say to the family, listen, because of this last one to die win scenario, we got to come up with a solution. So even if the husband leaves everything to the spouse, what he's going to do in this scenario is he's going to leave 20% to each of his two children. And let's say it's $1 million. They each get $200,000. And he's going to leave the remainder to his spouse. And she's going to get $600,000. Okay? Now, is that a perfect result? No. But he has a couple goals here. He wants to make sure his children get some money, and he wants to make sure his wife's taken care of. Again, this cuts both ways. I have a lot of cases where the wife's got the jumbo IRA, the big thing, and we're still in the big part of the estate, and we're doing the same thing. We want to cut out a piece for the first to die's children, and we do it on both sides. If she's got a 401 over here, we're doing the same thing to her kids, 20%, 20%, 60% to the surviving spouse. Understanding that also the surviving spouse, again, in these more modern families where both sides have 401ks or pensions, if they're teachers or state workers, etc., we can accommodate everyone's goals and still make sure that the children here get a gift. Now, on occasion, when someone comes to me and says, listen, how do we do this effectively? Because my spouse needs all the IRA money. So we're going to leave all the IRA money to the spouse. Great. Let's buy a life insurance policy. Let's buy it, let's call it $250,000, and we're going to leave that to your two children. And that's what they're going to get as their inheritance. And I say to them, listen, here's the deal. Let's assume that that's all they're going to get. That even though you guys have agreed to leave more money to your spouse or to your spouse's children, that doesn't happen. Are you comfortable that they only get and share this $250,000 policy? I'm comfortable. If they tell me they're comfortable, we've resolved phase one of this plan, leaving money to the blended family children. This is a good plan. It may not be a great plan, but it's a good solution. We use life insurance to accommodate some of the gifting to the first to die's children. So that's another way. So we got IRA splitting, we've got life insurance or life insurance splitting. Those are two good ways to do it. Now, that's not the only way. And I'm going to get a little more complicated. And this is where we get into some higher level thinking and some other issues, like if we have people that own businesses, or if we're seriously concerned about what happens when the spouse passes. So another way to do this, in lieu of leaving everything to the spouse, is to take assets, and instead of leaving to the spouse, we create a trust for the spouse. Spouse is the beneficiary. Oops, I can't spell spouse. And the spouse is also a trustee with someone. And we'll leave the life insurance, maybe even the IRAs, into this trust. Okay? Now, the spouse has this money and use of this money during the spouse's lifetime. The spouse has their own stuff over here. They've got their own money, their own life insurance. When the second spouse dies, all this money passes to this spouse's children, and all this money passes to this spouse's children. And voila, we now have a plan that's effectuated, leaving money to both of the children, and allow the spouse to be taken care of during his or her lifetime by using a testamentary trust. It's a good plan. It's a very good plan. Does it mean that there's a little more work here? Yeah. But when you're trying to accomplish a goal, like making sure all the children are taken care of, you have to spend a little bit more, and you have to spend a little more time getting the plan right. It's important to accomplish your goals, okay? And if your goals are important to accomplish, then you have to do a little bit of extra work. So that's a good plan right there. That's also a will-based plan. So it's not terrifically expensive. We're still trying to stay under the $1,000 mark for most of these plans, 1,000 per family. We really want to keep them affordable and effective. Okay. Now, what I've been talking about to this point have been utilizing will-based plans. We could, in effect, substitute these wills and call them revocable trusts. The result could be very similar to what we've done here. This is really particularly important if, for instance, the husband or the wife, let's say, has a business and might have a business that they want to pass on. We put it in a trust. The business goes in here, let's call it a corporation, and the corporation comes down and might go in a trust, as would maybe the life insurance into the trust. So we've got the corp and the life insurance for the benefit of the spouse during the spouse's lifetime. And when the spouse passes, again, corporation and life insurance or whatever's left over comes down to the children. Using the living trust takes it out of probate, makes it a little bit easier to manage, and we start to look at living trusts when we get into businesses, when we get into higher net worth clients, when we get into large investments and large IRAs, large life, as I said, life insurance. So once we get into the multi-million-dollar tier, using the living trust version of the plan is much better, just because we want to keep it out of the court system. It also means, for instance, let's say we've got multiple houses. We've got a house that husband owned before the marriage, the wife's got one she owned, or maybe she owns one up in the Adirondacks that she inherited from her family, and she wants to keep it and make sure it goes to her kids. All of these things are really, really important concepts to understand. I got this stuff I want to keep to my kids. I got this stuff that we want to go to my kids. It has to be part of it. It has to be a well-built, well-constructed plan to ensure that the family assets go the proper way. What we've seen in the past, what we don't want to happen, is we've got the new spouse ending up with all the assets, and the new spouse's kids get all the assets, and the deceased spouse's kids get nothing. I've seen that happen. I've heard stories. Everyone's probably got a story. That's not how things should work. You need to take a little bit more time to do a plan in these circumstances to get it right, so that we end up with everyone being treated the way they should and the way you want to. So, blended family, a little bit more of a challenge. Not going to lie to you, it's a challenge, but anything can be accomplished if we put our minds to it. All right. So, blended family, very important. Probably of the topics we're going to cover today, this is the most important one because it is the biggest challenge. Now, let's talk about the last big topic today, which are unmarried couples. And you might be surprised, maybe you wouldn't, how many unmarried couples don't plan. Now, unmarried couples, including same-sex couples, which, we have a number of those clients, have to pay attention, more attention, to doing estate planning. And why is that? Well, as I discussed earlier, New York State has a plan for you if you die without a will. Unfortunately, the plan that New York State provides is not a plan that will leave anything to someone who is not related to you. So if you are unmarried to someone and your intention is to leave them something, you either must do it through a will or through a beneficiary designation. It is irresponsible, and I mean that, it is irresponsible not to do an estate plan or a will that puts these things in writing to allow your significant other to inherit from you. You need it in writing. So that's the biggest issue you face. New York State is not going to accommodate your wishes if you don't put them down in paper and have it drafted and signed in proper form. You could face a serious contest from some of the family if you're going to leave your assets to a non-family member who could be a significant other, could be a friend. This could apply to you leaving it just to your best friend. Gotta be in writing. The biggest problem is I've had unmarried couples, and let's say this is the male, and he owns the house, and he never took the time to put the house in both their names. He always said, you're going to get the house, you're going to be able to live there, if something happens to me. And then he dies without the will, and guess what happens? His family gets the house. His brothers and sisters end up with the house. They sell it. She's out of luck. She's gone, and she gets nothing. Not a good way to go. So what this guy can do is he can either leave it to her, or he can put it in a trust for her, call it life use, or in a trust, one or the other, and allow her to use this house during her lifetime and still accommodate leaving it to his family, or just leave it to her. But if he doesn't put it in writing, if they don't put it in writing, it's a problem. And I've seen this happen multiple times. Well, we assumed we'd get it. I assumed it would be mine. Everyone knew it would be mine. The family has no problem. They're going to let me have it until they don't. Because when the family finds out that the house is worth $100,000 and they're each going to get $33,000, maybe they're not so happy letting the significant other live there or have it. So this has to be in writing, okay? You face the consequences if you don't do it, and you face the real prospect of a contest even if you do it in writing. So all of our wills, have a no contest clause or a contest clause in them. The contest clause says that if anybody contests the will and they lose their inheritance. So sometimes, if you're trying to disinherit even a brother, a sister, a child, you might give them a few dollars in the will. You might say, I'm going to give you $5,000. And even though some people consider that an insult, what it really is, it's a payoff. Because with the contest clause in the will, when they get this $5,000 and they say, you know what, I'm going to contest the will, they're putting that $5,000 on the table. It's like going to the casino, putting it down and saying, I'm willing to bet this $5,000 that I'm going to get more than I'm going to get this will thrown out. Well, that's a pretty big risk. Also understand that when you as an attorney, put a no contest clause in that will, that you take seriously your defense of that will, which means invariably there's almost no compromise. It's either good or it's not. Because with a contest clause, that means that the person is either in or they're out. And if they contest and they lose, they're out. So I take that very seriously, which means anytime, if anyone ever contested one of my wills, we're going all the way to the end for someone to decide if it's legitimate or not. We go to great lengths to make sure those wills are sound, they're intact, that the person was of sound mind and memory when they signed them, and that no one's going to get this will thrown out. Okay? So that is a challenge with unmarried couples. That is a challenge when you leave something to a non-relative, because the relatives may always try to step in and do something. So there's ways to get around that. There's things you should consider: using contest clause, leaving something to your relatives, or better yet, if you really want to leave people out and you really want to make sure no one gets their hands on it, you use what? A trust. Because a trust, if you have your assets in it, and if you leave it in trust for your significant other or a friend, what happens? If you recall, when I started this conversation on my other page, I said a will requires waivers to be signed. Waivers signed by those people who inherit if you died without a will, called distributees. Well, with a living trust, no waivers are required. Nobody signs anything. In fact, it is not necessary that the distributees even see the trust. They're not necessarily entitled to look at the trust. They can't see it. They're not allowed to know what's in it. And we still have a contest clause in here, but we don't leave them anything most of the time. They don't know what happens. The trust is very private. Everything occurs in our office. Ultimately, the significant other or the unmarried person or the friend gets the assets however the person intended, without much interference. So if we really want to take it out and keep people from creating problems, we will use a living trust in certain circumstances just to minimize those problems. But unmarried couples, again, critical. A lot of things are left in unmarried couple relationships through beneficiary designation. That's very helpful. But again, you may have a same situation where you don't like that person's children or that person's relatives, so you're going to use this trust to leave it in trust for them. Now, what's the distinction between this and married couples or blended families? I probably didn't mention this, but I should have. In a married situation, even if it's a blended family, if you leave everything you own in a trust for your spouse, the surviving spouse has a right to take a third of that no matter what. It's called the right of election. They can take a third out of this trust and put it in their pocket. That's significant and that's important. However, unmarried couples have no such right. They can't take a third. So when you put it in trust for an unmarried significant other, a partner, a friend, any of those things, they don't have a right to take out like a married or a spouse would. That's significant. Those rights attach once you're married. Once you're married, a significant amount of rights attach. I think everyone understands that, and so this would be without those rights. Okay. All right. The biggest lesson to learn in unmarried couples is you have to put it in writing. There's no other way to say it. There is no attachment of law that's going to provide for the unmarried spouse or the partner, so you have to have it in writing. Simple. Do it. Get it done. Do not waste time, and do not say I'm going to do it next year or next week, because as we've learned, particularly in the last 2 years, next week may never come, and this could really create problems for your surviving partner. All right. Again, as I mentioned, same-sex couples, same issue. Got to be in writing. Obviously, in New York, same-sex couples can be married, but they don't always get married, just like couples themselves don't get married. In this instance, got to have it in writing. So keep that in mind. All right. Now, I do want to address, since I have a few minutes, 3 to 5 minutes, I want to just cover one of the issues that I cover most of the time, but I think it's always worth mentioning in case I have new people watching. So we covered the basics, really important. Again, what's the most important? The power of attorney with the gifting power. We covered young parents. What's important there? Life insurance, will with a trust in it. Make sure the life insurance gets into the will with the trust. Bypassing creditors if necessary. Blended families, making sure your plans are properly outlined, that you leave something to your children in one way or another, either direct beneficiary designation through your will or through using a trust under a will. Okay. And finally, unmarried couples and why it's important to get your things in writing, because New York State does not provide an easy avenue to pass assets on to your unmarried significant other. Last one I want to cover, as I said, it's always important, is to talk about the irrevocable trust, because frankly, this is the biggest thing we do. And when I say irrevocable for our purposes, this is a Medicaid irrevocable trust. And what we're trying to do is we're trying to preserve assets in the event that someone needs long-term care. New York State's made some new long-term care changes. There are changes with home care. The world is changing, so staying up and current and planning ahead becomes even more important in any of these circumstances. And getting assets out of your name is always important, not just for asset protection, which is a big one, but also for asset management, avoiding probate, and passing assets on to the people you care about. So this is an irrevocable trust. As you can see, I draw it as a safe because these are the assets you want to protect. So usually it's a house, maybe it's a second home, camp, rental, Florida property, right? Maybe there's some investments, maybe there's some life insurance. What we're trying to do is preserve these assets, so if this person or this couple goes into a nursing home, those won't be available for the cost. The cost of care right now is about $12,000 a month. It's going up at a rate of about 3.3% a year, and that is becoming an issue because the assets can be eaten up very quickly at that rate. What has to stay outside the trust would be IRAs, 401ks, fixed income, and what we call mad money, which is your fund money. Usually, if you have it, up to and including about $100,000 plus or minus of assets, spendable assets, investable assets, things like that. Generally speaking, the life insurance, which would be included as an asset, would be placed in the trust just to get it out of your name. The number one rule with the trust, whatever you put in there, you cannot take out and put back in your name. That's a big rule. Must be followed. You can be the trustee. So that's important to remember because the trustee does what? Manages and controls everything in the safe. So for instance, if you're a trustee and you want to sell your Florida property and buy one in Arizona, the trust can sell it and the trust can buy a new one. As long as you're the trustee, you make those decisions. If it's been in here 5 years, it's 100% protected. Okay, we'll see. We're talking about new rules coming out. We're going to see how those play out. And if you ever needed anything in here, you can always give it to your children or other beneficiaries as a gift, and they, of course, can spend it on you or give it back to you. Now, when you pass, this will avoid probate. These assets will come down. Let's say this is someone with 3 children. This trust will create 3 new trusts for your children, understanding that at the time of your death, or at the time, I should say, at the time you plan an estate, you don't know what their life will look like when you die. So what we always do is we preserve their assets by putting these in a trust for them. Now, these trusts are created to protect them from what I call the 5 Ds. The 5 Ds are divorce, disability, disease, death, and death. And we want to be able to protect your children from those. In case any of those things are possible, which they are, we want to be sure that this money can't be touched by creditors or third parties. If they're healthy and they want to take the money out, they can. They can take some or all of it out. If one of them dies, it goes down to their children. Once again, down to the grandchildren in trust till they're 25 or 30, making sure that they're protected so that they don't do anything foolish with their wonderful inheritance. So that's the idea, is to protect the creator of the trust, the children, and the grandchildren right along here. So, a lot of flexibility in this trust. New York State gives and provides the ability to change who the beneficiaries are at any time. So that's a really big piece of the flexibility of the trust. Also allows the grantor to manage it and allows the grantor to change who the trustees are at any time. So very flexible tool. So in summary, we want to be sure you remember power of attorney. No matter what, you should do a will to protect you and your young children, to protect blended families, and to protect unmarried couples. Very important. Consider a trust to protect assets in case long-term care becomes an issue. It is expensive. But regardless of what we talked about today, doing a plan no matter what is really important. And you should consider doing that to protect your family from overburdensome administration when you're gone. Not leaving a will is irresponsible. It really makes a difference if it's spelled out clearly and they know what to do. Tell them how you want to be treated at your death. Do you want to be cremated, buried, any of that stuff. All these things should be in place to make their lives easier. Okay? All right. So I hope I imparted some good information today. This will be recorded and placed on Facebook so anyone can go back and look at it. I try to keep it 45 to 50 minutes, so it looks like we're just close to 50 minutes right now. Once again, I hope someday to be able to do these live. I can never tell if anyone's asking questions because obviously I'm not great at managing this. So, and I don't know how people ask questions. So I apologize for that. But let me offer this up to you. This might help. If you wish to ask me a question based on anything I talked about today, you can come and see me. That's easy. Just call 624-9600 and make an appointment. Come and see me. We can do a Zoom meeting after hours. I'm doing some Saturday work too, so it's 624-9600. If you simply want to send me a message or have a question, this is 315, obviously. My email is rkh@hiltonlawny.com. Go on our website. We also have multiple videos on the website. We have short videos that talk about various topics, really 1 minute to 2 minute long, little clips to help you learn quickly. If there's anything I can do, please don't hesitate to contact me. Thank you. Have a nice night.